Değerli katılımcılar ve ekran...
Distinguished guests, I would like to welcome you, each and every one of you, to the first International Personal Data Protection Congress. I hope that this Congress is going to be fruitful for all the parties. Today, on the second day of our Congress, we are going to have 6 sessions, and in the first session today, we are going to have Associate Professor Hüseyin Can Aksoy, Dr. Belkıs Vural-Çelenk, Dr. Aybike Tunç, and also Şehriban İpek Aşıkoğlu are going to deliver their speeches, and the moderator is going to be Professor Dr. Ali Kemal Yıldız, the Dean of Turkish German University Law Department. This is the first session of the second day of our Congress. We do have 4 speakers, and each will have 15 minutes. And we have to finish the session by 10:10. I would like to cut it short, and now I would like to leave the floor to Dr. Associate Professor Hüseyin Can Aksoy. He's going to be talking about data portability, right to carry data, and I will warn you at 10 minutes point, and thank you very much for your participation. Thank you very much, Mr. Dean, Mr. President. I would like to salute all of you, and I would like to thank organizers for this Congress. We are, getting connected online, and in the preparation process, I have witnessed how professional the organizers are, and I would like to thank them once again. If you allow me, I would like to share my slide. The data portability right, the purposes, functions, and the borders. Let me describe the concept first. What is that? Right to carry the data. The related person, the personal data can be taken by that person in a format which can be read by the machine, and the data carrier should not create any obstacle for that, and this demand should be fulfilled within 12 months, and this right has been brought by GDPR, and this is one of the most important rights that GDPR brought, and this is one of the most litigious provisions of the GDPR because of the results it carries. When we say that, related person is providing a personal data to someone, and this person has the right to carry them in a certain format, and this data can be given to another data officer. I think we are familiar with this, carrying the numbers, mobile phone numbers. The application is similar to that. Let's say that you are shopping through Amazon, and your shopping history is there, and this can be taken and sold or carried to another platform. Or you are listening to music in Spotify, and those music lists that you created during the years, you can take those lists and you can say that I'm going to continue with YouTube music, or I will also use YouTube music. You can carry them like that. And your files that you downloaded in Google Drive, you can take them in a format which can be read by a machine. You can carry it to another storage platform. there are 4 interests, and because of, there's a litigation, there's a conflict of interests here. That's why this topic is quite hot. The first interest is the rights of the related person. Related person has the freedom to define the result, the direction of their data. This is about informational self-determination right. The data about me, who is going to have an access to them, who is going to take it, or to whom I'm going to share them, with whom I'm going to share them. So that's me who is going to decide. This is related to this. And the second one is the protection of the competition. As you know, in an era of digitalization, certain data is clustered in some certain platforms, and some people might, avoid changing their storage platform. And for this reason, this right to carry your data is going to serve avoiding all the data to be kept in one single platform. Let's say that, I have been in the social media platform for the 15 years. I don't want to go to another social media, but this perception is going to change, and look-in effect is going to be overcome, and related people can get out from one platform with all the data they had in that platform to a new platform. And the third interest is supporting the innovation. We said that data has been collected in big platforms. In this way, with the right to carry the data, small entrepreneurs are going to be supported. If you give that right to the data owner, then it's going to support the innovation. And last but not least, European Union's purpose of supporting the free movement of the data. Let me talk about the conditions. In order to use this right, there are 2 basic main conditions. The first one of which is the processing activity should be based on the consent of the person or on a contract. If it is on your consent or on the basis of a contract, then you can ask to carry your data. And the data to be carried should be processed on the basis of the will of the data owner, and this right can only be used for the data that had been given to the platform by the data carrier. And the second condition is that the processing activity should be made by automatic ways. So it's, the data on the paper is not going to be transformed into digital format. Which data is in the scope of this right? When we look at the provision, related person, provides data to the data holders. It's open to conflict and discussion. Related person, with the active behavior, provided data. Let's say that that person downloaded photos or made comments on that platform. These are the data provided by the related person. On the other end, derivative data. What are those? These are the data created by the data holder. They analyze the data of the data provider and then made analysis. Therefore, this is not going to be scope of the right. The observed data. Article 29 working group, in their related report, they stated that observed data is in the scope of this right. This data is gathered from the behavior of the person. Let's say that location information of the related person, or the searching history of the related person or the heartbeat data from the wearable equipment. But as the provision says provided data, here, you're not providing that data in an active manner. Your location data, for example, you don't provide it in an active manner, but working group of Article 29, then if we only limit it to that, provided data is going to be commented as the observed data as well, but the derivative data is not going to be within that scope. There are three main rights of the related person: taking that, communicating it, and make it sent to someone else. 10 minutes. Right to take. The importance of format is the following. This data has to be given in that format so that when it's going to be transferred to another platform, it's going to be easy to process them. When we look at the transmission right, without any hindrance of the data holder, the related person can take that data and carry it to another platform. I can take my data from one data holder to another one. And there's also one more right. If it is possible from the technical perspective, data owner has the right to ask the data holder to transfer it to another data holder. I can take the data and transfer it to someone else, and also, if it is possible from technical perspective, I can ask the data holder to carry it to another data holder. What do they mean saying from technical perspective? In the GDPR's introduction, it says, data holders are encouraged to develop interoperable formats. This is not an obligation, but they encourage it, because if there is no format, interoperable format, then it's not going to be possible to process the data which has been received or transferred. Let me underline one fact. New data holder should use it only within the scope of processing the data, and the data owner has only responsibility to convey the data. And of course, security precautions need to be taken, but they don't have any obligation to monitor the rights which have been transferred. This right is a little bit like the right to have an access, but this is more than that. In the right to have an access, I would like to see the data, how you process it, etc. This is about it. But here you have the right to get your data in a certain format, or you can ask them to transfer it to another platform. Okay. And one more thing. This is important from the right to ask for the for erasing the data. And if related person doesn't ask them to be erased, then the first platform doesn't have the obligation to erase them. Maybe that person is going to use two platforms. Here, you only carry the data. If there isn't any demand, then the data in the first platform is not going to be erased. And the scope of the right and the limits of the right in GDPR, it says that this is the fulfillment of a responsibility for the benefit of the society. This cannot be applied to them because processing activity should be on the consent or the agreement that the related person signed, this right is not going to affect the freedoms of a certain person in a negative manner. Commercial limits should not be exposed. I mean the data holders. And also intellectual property rights of the data holder should not be violated. Let's say that there is a group photograph. Others' freedoms are going to be affected. How are we going to carry that data? This question has to be answered, but we know that the financial benefit of the first data holders are not going to be taken into consideration. In the last slide, let me talk about the criticism. The first criticism brought is that the observed data should not be within the scope of the provision, and the second one, in which format the data is going to be presented. You know, it's not certain, and this uncertainty is preventing the use of this right, de facto use of this right, and this is the criticism. And in this regard, in Payment Services Directive second and the standard created according to that, so they're showing it as an example of the standard. There are questions about that. And last but not least, the negative effects that it can bear from the perspective of the competition law. In order to create positive competitive effect, it might create negative effect on the competition law, especially for the SMEs. It's going to require adjustment and adoption costs. Therefore, it's going to be exactly the opposite, and maybe an exception can be brought to the SMEs in order to recover them from the high costs. And at the EU level, these are the discussions made about it. Thank you very much for sticking your time in such a short period of time. You made it very clear, and I'm sure that everybody understood it very clearly. Thank you very much for your participation. Now, I would like to proceed with our second speaker.
Çelenk, Avrupa Birliği.
Dr. Belkıs Vural Çelenk will be talking about the evaluation of the practice of the adequacy decision for transfer of personal data under European Union, Swiss and Turkish law. You have, unfortunately, 15 minutes. Thank you very much for your participation. Thank you very much. I'd like to share my presentation. I'd like to thank everyone who has spent their efforts for organizing this event. I'd like to send my salutations from Ankara, and I'd like to also extend my respects everyone who are watching and listening to us in front of their screens. I'll be talking about the evaluation of the practice of the adequacy decision for transfer of personal data under European Union, Swiss and Turkish law. First and foremost, I'll be talking about the concept of international transfer of personal data, but unfortunately, because of the time limitation and your sensitivity for time limitations, I'll be just skipping certain issues. And if you wish, we can talk about EU part of the data transfer. Because I just want to also compare our domestic law and EU law. So I'll start with the law in the EU, which is the core about our topic. I mean, this is the adequacy decision that I want to talk about. In the 8th article, of the GDPR, it is mentioned that personal data is protected as fundamental rights. And this is very important, we know that. Specific to EU, when the data transfer is going to be towards a third country, we need to understand whether that control is close to the country that this data transfer will be made towards. When the data is disclosed, what kind of mechanisms can be used to compensate the damages? For that reason, EU has a concerning approach for the adequacy decision. So in the EU law, when adequacy decision is given, data transfer is assumed as a data transfer inside the EU without requiring any other condition. Data transfer can be made in the intra-EU countries. But according to, again, GDPR Article 45, we can also talk about that European Commission is entitled to determine the countries that provide adequate level of protection, but also under the details of the Article 45 of GDPR. By the way, this is titled as transfers on the basis of an adequacy decision. And I'm talking about the country having the adequacy decision. There is a description here, differentiation here, because yet Switzerland, or else it could be a different country, a different organization, different body. It's not specific to countries. It could be also a certain institution, so it is not limited to countries. And this is partial adequacy, and there is also the full adequacy decisions. And when it is a partial adequacy decision, it could be the transfer of the data to a region or a specific sector to a third country. For instance, Switzerland and EU accepts the transfer of data which is limited to commercial organizations in Canada. This is the decision given by European Commission, or else it could be an international organization. Schrems II decision of the EU, it's a very popular decision, as you all know. Privacy Shield. Privacy Shield is a great example for this EU Commission decision, and EU Commission and the USA's inter-transfer data examples. And according to the GDPR Article 45, European Commission has the right to give decision for the adequacy when we talk about transfers outside of EU, and also EDPB's decision, opinions, and also with the approval of the European Union countries' representatives, decisions for transfer of the data could be taken. And on the GDPR Article 5, it is mentioned that when it is about the law, rule of law, and also fundamental rights, human rights, public order, safety, security, national security, criminal law, so, and also public institutions, including all access to personal data. Also, public and sectoral legislation must be applied based on the GDPR rules. And again, we can also talk about the independent authorities availability, whether there is an authority protecting the data. European Commission says that the commitments of the countries outside of EU when it comes to personal data transfer are also going to be evaluated when there is such an issue with respect to transfer of the personal data. And there could be even much more details. For instance, there is this UK decision in 2021, June. A new decree has been issued, and on the website, this is what we have seen. European Human Rights Court has actually recognized the jurisdiction authority according to the 180 article of the Human Rights Convention. UK was, of course, given that approval, but of course it is not sufficient. Other kinds of approvals are also sought, and currently there is 21 countries and also 3 countries member to the European Economic Zone, Norway, Iceland and Liechtenstein, but of course Switzerland is not included to this zone. As for third country, European Union Commission gives this adequacy decision just specific to Switzerland, and it gives adequate protection for Switzerland. But this is the list. Time is very limited, that's why I'm just giving you some general framework. I'm not going to details, but you can see Switzerland here. So for Switzerland, in order to provide adequacy decision, still certain processes are ongoing, and as of this moment, European Commission carries out its works with Southern Korea, and I can also mention that. So when we look at the Swiss situation, actually I think today's meeting is very crucial, because in Switzerland revised 1992 Federal Data Protection Law, and in the first quarter of 2022, GDPR's maybe little sister, which is the Federal Data Protection Law, is going to be implemented. And as of this moment, adequate protection decision. By the way, there is a very long name of this Swiss data protection institution. It's a very long name, but I'm just giving you the abbreviation. So FADP institution says that it's not going to be binding, and it has certain consequences, legal consequences before the courts. It could be certain discussions, and also along with the 16th article, there's going to be new implementations. Actually, in Europe, European Commission's functions could be also similar to Switzerland's authorities for data protection. And this authority also says that Federal Council is going to give the adequate decisions. Belkıs, you have already finalized your 10 minutes, and you only have 5 minutes to go. Thank you very much. When we look at this Federal Data Protection Law, which is going to be enacted in 2022, and also this regulation, Article 31, gives the authority and right to carry out evaluations to Switzerland Federal Data Protection Authority. And there is this comparison with other countries. For instance, a natural person's data transfer in Switzerland, if it is going to be towards EU, then it is under protection. In Switzerland, both natural and general persons' data are under protection, and it's not also important whether it is regulation or law, but the important thing is its implementation. And also this is very crucial with the values of Swiss law on the basis of privacy of the private life and secrecy, confidentiality of the private life. I'll just skip this part very fast. In the Turkish Civil Code, we see protection of the data in the Article 9, and personal data can't be transferred to other countries unless there is the open, explicit consent of the persons. This is what Turkish law stipulates. But there is this difference with European Union law and Turkish law. So for the data which is not having some special attributions, processing conditions are taken from the General Data Protection Law, Article 5.2. For the special feature, special data, some other detailed articles are applied, and according to the ninth article of the General Data Protection Law, we also look at some international treaties that Turkey is a party of, and according to the 4th paragraph, we again look at the mutuality situation with Turkey, another country which is demanding for the data, and also the purpose of the processing, and the time, duration, and the purpose of the processing, and also legislation and its implementation about the data. These are some of the conditions that Turkish law is attaching importance. And again, in the law, we know that there is much more detailed set of criteria, and I've also checked it. So again, first and foremost, we can see mutuality, reciprocality situation, and also the implementation of the regulation in the relevant country. There are some subtitles underneath. For instance, there must be independent data protection authority availability. This is very crucial when Turkish courts take their decisions. It is the same with other countries as well. And being a member to international organizations, and also being a party to international data protection agreements, and also trade volume with the relevant country. These are important things. Because of the time, I'm skipping very fast. There is this prerequisite for the legality, both in Switzerland and European Union. I did not mention that the condition is sought for. Without a doubt, in the mutual relations, there could be certain de facto situations are required. I'm saying maybe because countries are applying to data protection institutions in other countries, so this processes could be initiated like that. But behind the personal data protection, there is some warranties, assurance. This is certain things that should not be affected by the relations between countries. So legality should be maybe open to criticism. And it says that trade volume could also be taken into consideration. I think it is something appropriate, because even though some countries are not member to EU, for instance, in Turkey, we have very great developments, but in EU, there are certain countries that we have great trade volume, and in order to enable the lives of the companies that they work with, even though they are members of the economic zone EU, in order to protect Norway and Liechtenstein, certain decisions could be issued. Thank you very much.
Biz de size çok teşekkür ederiz.
Thank you very much for your presentation and for sticking to your time. This program is going to finish at 6. That's why we had limited amount of time. Now we are going to proceed with our third speaker, Dr. Aybike Tunç. She's going to be talking about personal data and data trade. Thank you very much. I would like to thank to the organizers of this symposium and for inviting me. As stated by my professor, I'm going to talk about personal data and data trading. In the previous presentations, Hüseyin Can and Belkıs mentioned about the transfer and communicating the data. While our personal data is being transferred, the online platforms, we don't pay them mostly. we let them use our personal data, and in return, we don't pay anything. And these platforms are using this personal data to create an income resource. They are selling them, and they are getting that income from those sales. In this presentation, I'm going to talk about the sales, under which conditions the sales happen. This is what I'm going to focus in my presentation. What is the legal status of personal data? The legal quality of the personal data. There are three different opinions in the doctrine. First one of which is, in Anglo-Saxon law, the personal data has a financial value, therefore it has to be considered as a goods, and it's something which can be traded. And within this perspective, there are two different opinions. Personal data is a continuation of a person, and it's the goods, and it should be handled within the Code on Intellectual Property Rights, and they need to be protected accordingly. And personal data should be handled as an property, intellectual property, and then it should be protected by the related law. And this approach is not convenient for our law or European law, because if we consider the personal data as goods, then the personal data becomes goods. But when we look at the law, nothing belonging to that person, it's not goods. The organs, for example, even if they are separate thing, they can't be considered as goods. And in terms of intellectual property, our personal data is not produced as a result of a creation process. Our credit card number, phone number, these are all personal data, and while gathering these numbers, we don't exert any effort. We don't put any personalized effort. Therefore, it's not compatible with our law or the continental European law. And there's another perspective saying that personal data is a part of human being, and it's a basic fundamental right of human being, and it should be protected accordingly. Another opinion, other school says that there is a personality right, and it should be protected within the civil code. The closest one is the last one. Personal data is a part of a personality. We need to accept that. And in our law, in our legislation, the right to protect the personal data is arranged in the Constitution as a fundamental right and freedom. And also in our Personal Data Protection Code, we do have provisions to protect the personal data. Before the Personal Data Protection Code entered into force, it was handled in the civil code as the personality rights. And the last opinion in the doctrine is that personal data is an independent right. It's not a fundamental right or a personality right. It's a sui generis independent right type. Therefore, there should be a brand new rules, and within the framework of those rules, personal data has to be protected. I don't find it logical, because our existing laws are sufficient to protect the personal data. Sui generis or independent or something, I don't think it's logical to bring such an idea. Personal data is not good. Before defining that, how are we going to trade it? Because when we look at the Code of Obligations, the sales agreement, the seller is going to take the ownership of the buyer, and the seller has to pay an amount to the buyer. This is the definition. When there is a sales agreement, the parties should agree the cost of the sales and the object of the sales. These are the conditions of the agreement, and what's going to be, the sales object. It should be movable or immovable or non-material asset or right or receivables. We say that personal data is not goods. It's a fundamental right, a personality right, but the rights which are the subject of the sales agreement, it's not possible to put personality rights to the sales agreement because personality rights are inalienable rights. So how are we going to handle that? We call it anonymous data. In Article 3 of Personal Data Protection Law, anonymizing the data, it's defined, and the code says that matching personal data should not be related to anyone specific. We can say that the anonymous data cannot be associated to anyone in any ways. It's just an ordinary data. It's not different from an ordinary data. I mean the annual balance sheet data of a bank and anonymized personal data, they don't have any difference in terms of legal quality. Both are just data. And we need to look at the definition of GDPR. GDPR defined anonymous data, not anonymizing the data. This is not going to be about a real person or the owner of the data has been anonymized, and this is not personalized. As you can see, it has been separated from the personality element, and you cannot get any association or any connection to that person. When we look at the legal quality of the anonymous data, there are different approaches. This might be an intellectual property or independent sui generis right. I'm not going to go into details because my opinions are parallel in that regard. In German law, there is one approach saying that it's like goods. In German code, in civil code, German civil code, goods were defined very clearly, and they made an arrangement saying that the goods have to be material. Therefore, in German code, it's not possible to define legally anything which are not material. And these online platforms are having income with the personal data of their users, and in order to answer it, as they couldn't say goods, they said goods like protection. And this is their opinion. When we look at our law, as I stated earlier, our lawmaker didn't make any definition of the goods, and the definition of the goods was made in the doctrine. Okay, let me wrap up. And in our law, we don't have any law which are limiting us, calling the data not goods just because it's not a material. I think it means we have been left behind the digitalized world. When we look at the quality of the goods, alienable, it should have financial value, and in the doctrine, there's a condition to be material. When we look at data, data has a serious financial value, so much so that it's called as the new oil, and it can be transferred. In the first two presentations, it was explained, how this data can be transferred. And even if it says materialized asset, even the data itself is not materialized, but in order to use this data, in order to make the data to be useful, this data has to be stored to a certain place. Data is not something which is suspended upon the air, We put it somewhere, we store it somewhere. Just because it doesn't have the materialized value, I think it's not right to call it as goods. I think it means we have been left behind the digitalized world, and I think we can't catch up with the changing world if we continue calling it so. Data trading, if we accept anonymous data as goods, then personal data, they can only be traded after being anonymized, and they can be a subject of trading only if they are anonymous. About data trading, I haven't found any regulation. I think this has to be fulfilled, and data trading has to be regulated specifically, because data is not like an ordinary good like Apple, furniture. In Cambridge Analytica scandal, it might result in very serious consequences. Therefore, very important regulations have to be made in that regard. This is my presentation, and thanks for listening. Thank you. Thank you for your presentation, and thank you for sticking to your time. And you have provided us with really important information. Now, Şehriban İpek Aşıkoğlu is our fourth speaker. Right to get information and also commercial secret conflict.
Çok teşekkür ederim hocam. Öncelikle ben de İstanbul Üniversitesi'ne...
Thank you very much. I'm really happy to be a member of Istanbul University, and I'd like to thank Istanbul University and Turkish German University for having this congress today. I'll be talking about contradiction between trade secret and right to be informed in digital era. In my presentation, I'll be talking about the process which takes us to information era, and I'm sure that the ones who are following us on the online platforms and also people in this room have listened to this story very much, I guess, because it's all about industrial revolution and also big data and big internet world. But I'll be repeating it very briefly. I'm going to do this because of certain reasons. When we have a look at the very basics of the personal data protection, what is the main factor here when it comes to the relevant person's protection? It's related to facility of the person's control of its own data, and I'll give you the perspective of it, the historical perspective of it, and then I'll be mentioning what kind of possibilities do the controllers of the data have in terms of asking for their data rights, and also I'll be talking about whether they have the right to object to intellectual property rights and also commercial secrecies, and I want to give you certain informations in this regard. Thank you very much in advance for listening to me. As I've stated beforehand, so this has started with the Industrial Revolution, with the steam power, and then serial production was made available, was made possible, then automation after that. Today we are talking about Industry 4.0. Right now we are talking about machines and also robotic production, it's much more technological. Manpower is lagging behind. This is what we are talking about today. And also with these visuals, by the way, I've selected them from the internet, and you can also have the resources. What did I do? I just wrote tech evolution and machine evolution. And when we have a look at this kind of resource, especially when they're on a timeline, we can see that this time interval between these evolutions is getting much shorter. So here you can see 1784, 1870s, 1969, and today there is even not 100 years between today and 1969. So here we have seen unprecedented pace and speed in the development of the changes. So the ones who are listening to us on YouTube, I'm sure that they can all appreciate the changes in our lives. Maybe a couple of years ago they were using certain things, but those things right now are accepted as some antique products, because information is increasing. Information also is triggering the production. For that reason, thanks to that, we can have higher technologies, we can have better development on the information technology. Likewise, this is something that I've taken from internet, and I believe it could give us the nostalgic effect. So starting from 1940s, 1930s, 1940s, this is the invention of computer time. So as of this moment, we all have computers at our pockets, maybe, right? So this is something that we feel with internet in our own lives. With the development of the machines, internet has also developed. This is again very important. And before internet, communication was not only made possible with the landlines and also SMS text messages, but with the invention of internet, we can also talk about content or emails. And internet was not a place where people that much participatory, but along with the social media, Web 2.0, content production and e-trade was made possible, and people became much more involved in the process. And along with the internet of people, we can see social media, Facebook and YouTube. Right now, everyone can produce content very fast, however they wish, and we have the Internet of Things ahead of us, and there's going to be Internet of the devices, machines, and more data is going to be collected. This is what it means actually. So when we have a look at the development of machines and internet, why I mentioned that there are certain reasons. When we have a look at the studies with respect to data protection, if we have a look at European side of it, we can all see that 1960s, 1970s, when the computer entered into our lives, in public sector, automatic data processing started to happen, and also with the data bank, certain processing took place, but here with these words, maybe we can also talk about data protection history. So in the very beginning, in the United States of America, right to be left alone, right to be left alone was mentioned, and also this privacy right was added to Human Rights Convention. But along with the development of the technology, by the way, I'm still talking about data banks in 1960s, 1970s, they triggered the automatic processing. Along with this transformation, I think there were certain changes towards data protection. This is different from privacy. In order for data protection, it is not a necessity that it must be in a secret or confidentiality area. And because of the processing of the personal data, people could be exposed to certain things, could be subjected to certain things. There were discussions about that in the first times in Germany, in Hessen. There were certain regulations for automated data processing in the public sector, and then again it was related to population count. Under this law, data theft was included was described as a crime, and then European Council started to carry out their works in the 1960s. European Council started its work, and it was related to automated data processing. This was what European Council was focusing on, and also in 1973 to 1974 in European Council there were certain decisions announced with respect to electronic data banks in public and private sectors. In 1981, a Convention for the Protection of Individuals with regard to automated processing of personal data. So actually that Council's decision paved the way for 1981, and in these processes we can see automated processing of personal data. Still, along with the automated processing, what kind of rights must be given to the natural persons? It was still ongoing discussions till German Federal Data Protection Act, because this data was related to self-determination, and this is very much related to our own law. This has been evaluated and also analyzed in our law. So very briefly, I want to talk about this issue which led this decision to be taken. So in 1982, actually, anonymously, there was this population count law. It was on the agenda, and there were certain discussions on the Grand Assembly. Only the financial size of it was actually discussed, but after it was accepted, then there were many protests against this decision, because there were many demands for information, and when it was taken to the Constitutional Court, this was the result. So the court said that people should be given their self-determination to set their future and their decisions, and collection of the personal data, recording it and using it, processing it, should not be given to some authorities. It was defined in this law, and this is going to be also related to my own topic. So especially here, the content of the information. If persons don't know what kind of people are using their information in what purposes, these people should have right to decide about their future, about their also movements and acts with respect to their personal data. In 1995, with respect to the personal data protection, the directive was accepted and adopted. By the way, till this time, certain data processing protection had been related to automated processing, but here we can see certain differences. Even though non-automated processing data was under the protection of the law, and relevant related people could have the control about their data. When I have a look at the history of the personal data, I can see these keywords like privacy, right to be left alone, data protection, and also protection of individuals with regard to automated processing of personal data, rights of informational self-determination, which also paved the way for the formation of GDPR. These are four main points. So here there is this also an important part which is about this technologies. Technologies must be human driven, and also there must be real authentic control over the technologies, and who should have the control over the data, in what ways the real authentic control must be provided with this kind of regulations. That control could be also analyzed. And for the protection of the personal data, it should not be necessarily private or secret, because due to its consequences, maybe for that individual, even an ordinary information with this different kind of processings could lead different consequences. So in the personal data protection law, this is the main reason actually, and transparency, how to provide the transparency. These are some of the important items in the personal data protection law. By the way, you only have 5 minutes, and for individuals to have information over their personal data. We can also check Article 12, 13, 14, 15 in GDPR. Here you can see transparent information, communication and modalities for the exercise of the rights of the data subject. Information to be provided where personal data are collected have not been obtained from the data subject. And Article 15 talks about the right of access by the data subject. And when it comes to the right to disclose the information, this is not related to the demand of the individual. In terms of the accessibility rights, there is this right, specific information which is to be given to the personal individuals, but this is something special and it must be related to the individuals. But I'd like to talk about this. Whether some additional rights are given to individuals, and also a contradiction between trade secret and right to be informed in digital era, whether these are harming the individuals or not. So when we have a look at these GDPR articles 13 to 2F and 13 to G, 21.4, 22.3, it says that the existence of automated decision making, including profiling, and meaningful information about the logic involved, as well as the significance and the envisaged consequences. So if there is an automated process decision mechanism, then underneath the algorithm with respect to rationale, meaningful information must be given to the persons. So with respect to these articles, maybe there is this criticism available. So because in the first place, these automated decision-making mechanisms are mentioned. For that reason, the implementation of this law is very limited. And the second criticism is that it's not about the rationale behind this automated decision-making, but it's just about the existence. It's that they say that it must point out that it is available. The existence of these must be pointed out, but the working group is not supporting that. If there is a decision-making tree underneath these mechanisms rationale, what kind of data is chosen, what is the significance of this information, meaningful information, these should be transferred to the individuals, but working group are a bit disappointed because of certain implementations here. They say that information asked underneath these accessibility rights should not be significant. Some general information could also be given. This is the comment from the GDPR side. So what is the balance between the individuals and also data controller? With respect to individuals, I've already mentioned the important parts. When it comes to data responsible person, data control, in intellectual property, and also the secrets, trade secrets, first and foremost, providing, disclosing the initial information is very crucial. And I'd like to talk about the trade secrets. June 9, 2017, Trade Secret Directive was enacted, and in this directive there's just one item. This is GDPR Recital 63. It's talk about that right should not adversely affect the rights or freedoms of others, including trade secrets or intellectual property, and in particular the copyright, protecting the people. But in the recital of the GDPR and in the recitals of the trade secret directives, we can see there are certain refers to one another. And on the GDPR, again, this is what I've mentioned before, and on the trade secret directive, it says that directive shouldn't affect the rights and obligations laid down in Directive 95/46 European Commission, in particular the rights of the data subject to access his or her personal data being processed and to obtain the rectification, erasure or blocking of the data. Actually, these two are sending the ball to one another, passing the ball to one another. They are not either superior or prioritizing to one another, and there is this advisory effect. And the other on the GDPR recital, it says that rights should not adversely affect, and the other one says it might affect. So, but I'd like to give you the background of it with respect to right to access. Max Schrems applied at Facebook, and Facebook rejected a part of this application because of the trade secrets and intellectual property rights issues. But there are certain effects of this decision. In the next trade secret directive proposal text, Commission formed its opinions about that. I guess I don't have too much time. So, as I've said it beforehand, the Commission says that in the new directive there must be relations between trade secrets and also personal data, and trade secrets should not be interpreted in a way to limit the rights of the individuals. This opinion was announced, and as a result of that, we can see this kind of expressions in certain legal justifications. Is this a threat? I'd like to talk about two important decisions. In Belgium Data Protection Authority, we can see a decision from 2021 with respect to protection of the trade secret. If there is a threat, by the way, there's this example, the applicant's opinion was rejected, and this is something concrete, and it was proven. That's why Belgium Data Protection Authority accepted this decision, but maybe a corrected copy could be given to the individual. Again, in the French Constitutional Court, we can see a very different decision. It's related to automated decision-making mechanisms. In the annulment of the administrative decision, they say that no, these algorithms should be explained all the time. It's not about trade secrets, or else it's not something that should be evaluated under the intellectual property rights. Very briefly, I'll talk about the solution recommendations. If it is an handicap with respect to trade secret, if there are some reservations, then there could be some disruptions from the personal data content. Is it really necessary to provide the individual his own personal data? Maybe there could be some accountability processes for algorithms might work. So, for instance, if we can test an algorithm, whether it is trusted or not, with a certification mechanism, then we can not talk about the right to access to his own personal data for individuals is not satisfied. The basic principle is that individuals might say, okay, that's going to happen to me, I'm not going to be harmed at all, but he or she is not going to be given his personal data. Thank you very much for your attention.
Biz de çok teşekkür ederiz. Yine önemli bir konuyu bu kadar kısa sürede tekrar anlayışınız için teşekkür ederiz. Sunumunu yaptınız. Şimdi zamanı aslında verimli kullandık ama
We've used our time very efficiently, but our youngest actually talked the longest, so we don't have much time, but I want to give the floor to you if you want to say some other words. Maybe we can have those words in the last couple of minutes if you don't have anything. Our online panelists, is there anything that you'd like to add?
Hocam ben çok kısa bir şey eklemek isterim.
Let's underline the most fundamental thing. We mentioned about to right to carry, but this has not been regulated in Personal Data Protection Code. And this matter has to be handled well while reflecting it to Turkish code. And within the framework of GPDR, especially the interest balances, to protect them, it should be handled from the dimension of personal data protection and the competition law. It's a matter of multi-dimension, multi-step. Thank you very much. Thank you very much. There is nothing I would like to add. And when the book is published, you can have a look at that. Thank you very much. We thank you for your presentation and for your contribution. We have completed this first session and 10 minutes of break. Thank you. Our third session has ended. Thank you very much. Now we are going to have a coffee break of 10 minutes. Then we will...
ve bizleri ekranları başına takip eden izleyicilerimiz. 4. oturumumuzda Sayın Doktor Rahime Erbaş,
We are going to proceed with our fourth session. Dr. Rahime Erbaş, Dr. Gizem Gültekin Varkonyu, and Dr. Nafiye Yüceda. The moderator is going to be Associate Professor Mesut Serdar Çekin. The floor is yours, distinguished President. Thank you very much. I would like to say hi to everyone watching us. My deep respects to you all. Today, in our fourth session, we are going to have 3 presentations, first one of which is going to be made by Dr. Rahime Erbaş and Büşra Hazel Ateş Sarıdağ and Ahsen Akdemir. They prepared this communication together, and Büşra Hazel Ateş Sarıdağ, public prosecutor, is going to present, and then Dr. Gizem Gültekin Varkonyi is going to be making her presentation, and we are going to complete our session with the presentation of Dr. Nafiye Yüceda. We do have 55 minutes in total, therefore 15 minutes for each speaker is allocated. Then maybe now I would like to leave the floor to Büşra Hazel Ateş Sarıdağ for her presentation. Thank you very much, Mr. President. Distinguished professors, distinguished participants, I would like to salute you all and thank you very much to the organizers. We prepared our presentation with Dr. Rahime Erbaş and Ahsen Akdemir. And we want to bring different perspective. And I will be talking about DNA data repetitive usage in criminal procedural law. Criminal procedural law is one of the law personal data is being used, like the fingerprints, and the health data acquired by the examination. And from our perspective, this is the basic and fundamental unit of the person, and this data is being used in the criminal procedural law. And we can say that it's possible to apply to DNA evidence by means of molecular genetic analysis. Criminal Procedure Code Article 78 in the case law of the Court of Cassation, not applying to it, is a situation that requires an overruling judgment. And also, in addition to this, DNA evidence is a type of evidence that includes genetic data. Genetic data were also listed in the sensitive personal data group in the law on the protection of personal data in 2016, and with it, the processing conditions of these data were regulated separately, and DNA evidence is spatial characteristic personal data, and we can say that this is an exception to process, and for the automatic processing of the personal data, there is a recommendation decision by the Assembly of Ministers, and this can only be managed by law, and this data can only be used by preventing a crime or trying to find the committer of the crime. And in order to set up a national DNA bank in 2007, DNA data and national DNA data bank draft were prepared, but then it was not entered into force. We don't have that right now. DNA data is being gathered within a concrete file, and whether these DNA data can be used within a file, and the proof value is important. And within the scope of the file, even if we do have sufficient evidence, if there is an example which have not been analyzed in the file, this decision is being changed, amended, and this is, we need DNA data, especially for specific type of crimes like sexual assault. There are two main fields that we can use DNA data. Thief crime, and the thief leaves an example of blood while he was trying to escape from the window. The window is broken and his arm is cut, and also the fingerprint is matching with an existing one. We have a suspect now, and this suspect defends that, I was there beforehand, and whether there is any perpetrator or not. And if there is an example in the file, this blood needs to be sent for analyze. We get example from the suspect. We need to get the examples of the suspect. We need to apply criminal procedure law, Article 76. First, this decision has to be taken, and then blood or similar example like the hair, the upper level of the crime has to be more than 2 years. And these examples, these samples can only be taken by the doctors in line with the 75th article of criminal procedure law. And in order to have the molecular analysis on this sample, we take the decision in accordance with the 78th and 79th of the criminal procedure law. The sample is being given to the laboratory without giving the identity of the sample, and they're separate authorities, and they're called as the experts and police criminal laboratory or gendarmerie police laboratory or another institution. And these DNA samples, these swab sticks, after the expert prepares the report, they are being destroyed in line with the 14th article of the regulation. DNA isolates will be kept for a year in the in separate authorities, and then allegation is being prepared. Second paragraph of the article 18th article of criminal procedure law is showing us the conditions to destroy DNA sample. Acquittal, for example, and we can understand that in the files of which the perpetrator has not been found, DNA data should not be erased, and DNA analysis data is kept within the system, and it's not a physical environment in which they archive it, but criminal laboratory, department presidency, they do have DNA data analysis system, and in DNA database, police department has now have a DNA data bank right now, database, and this bank is being mentioned in the decisions of the Court of Appeal. There are two different definitions: the sample data, which has been gathered from the evidence in the crime zone, and the other one, the sample taken from the suspect. Gendarmerie doesn't have such DNA bank. The police department has. They integrated their systems, and in Gendarmerie, they gathered their information together, these files, and when they combined their databases, many crimes have been solved. DNA profiles are being coded and they are being kept anonymous. But as a result, let's say that there's an acquittal decision and no criminal punishment, then this data can be kept with identity. And we don't have an audit mechanism to control whether the identity should be there or not. If we have the decision coming from the court to erase the data, it's being erased from the list. DNA profile and DNA sample are two different concepts, but the profiles are being meshed to other profiles. It's such a data, and DNA data bank is not going to be biological data collection bank. It's only scientific database. The codes are going to be kept at. The second one is the repetitive use. Let's say that the person has completed its service in the prison and then exits the prison, and then he commits another crime, and there is no, let's say, witness, but there's a cigarette, and we can have molecular biological analysis with that cigarette, and we send it to for analyze in the laboratory. We don't have anything to match, but we would like to have the finding if it belongs to a man or a woman, and in advanced analysis, color of hair, color of eye can be defined, and then that cigarette part has matched with the genotype of the previous person in the second file. And in the expert report, it says that they don't give us the open identity. They are making reference to the first file. If the first sample was coded, then this reference file is being mentioned in a coded manner, and we can ask information from this file and learn about the identity. And Court of Appeal, for example, 17th Department of Crime, they say that it is a single DNA profile, and DNA profile matching is going to be against law, and they say that if there is no match, when we look at those decisions, there is no litigation about it. Within the scope of the previous example, there is a legal gap in archiving, but this data, there is a DNA database right now, but using the data out of this database is something else, and it can only be reused by the decision of the judge within the scope of the concrete event. This data can be taken by the judge in line with the law. And there is one point we need to be underlining. Criminal Procedure Law 79, name, birthday, or the address. If this is not given, only the code has been given, then it is not personal data. But if it is associated to a specific person, then it becomes personal data. All these practices, we can say that DNA database bank has to be established. And like the fingerprint database, it has to have legal basis and, comparative legal examples, or we need to have a separate law to set up DNA database bank. And also there should be a specific time frame to erase it or to keep it, to store it, and all of them has to be taken into consideration while setting up the bank.
Sayın savcımıza çok teşekkür ediyoruz. Hem zamana ziyadesiyle riayet ettiğiniz için hem de ama asıl...
Thank you very much for your very valuable information, Ms. Prosecutor. Thank you very much, and I'd like to make a private presentation here. And DNA data is very crucial in two aspects. Even though I'm not a DNA legal person, but DNA information matters in terms of national security, the storage of DNA, and in what ways it is going to be stored, and transferal of the DNA are arranged in some countries, and some countries in the world prohibited the transferal of DNA of their own citizens to other countries. And after Schlem's 2 decision, DNA-related issues have become important for public access to personal data, because, as you mentioned, there is a big need, but there is not a gap in the positive normative law. There is no legal basis for that reason. Turkey could be accepted as the safe and secure country, and especially from European Union, there is some data transferal to Turkey, and it will bring also problems along with it. For that reason, your presentation is very valuable. Thank you very much. And now, next presentation will be delivered by Gizem. But before proceeding with your presentation, I need to mention that your background seems very cute. What are the names of your friends back there? I haven't named them yet, but maybe we can give them name together. I think they are looking for data together. Gizem will be talking about evaluation of the proposed AI Act from the aspect of data processing for law enforcement purposes, cases of predictive policing and biometric data processing. I think it seems to be a very valuable presentation. Thank you very much, esteemed presenters, esteemed audience. Thank you very much for this opportunity. And I am in Hungary, Szeged city. It's 8:30. Unfortunately, I didn't know that there's going to be simultaneous translation. For that reason, I prepared everything in English. I know that everyone is going to be very much attentive. I'll be speaking in English.
Thanks to all organization committee and all All right. So my name is Gizem Gültekin Varkoni. I'm a senior lecturer at the University of Szeged, Faculty of Law and Political Sciences, International and Regional Studies Institute. I have been dealing with personal data issues since 2016 from the aspect of artificial intelligence technologies for the first sight, and besides that, of course, emerging technologies. But today I'm going to give you some basic problems, basic issues about predictive policing and biometric data processing activities under the proposed AI Act, because this area it is regulated already, but there are many national cases, also EU-related cases that are still remaining uncertain. So whether the proposed AI Act can give us some certain answers or not, we will see it at the end of the presentation. So a very brief introduction about predictive policing is the basis of the algorithmic assessment, right? The prediction is what we do under the statistics and artificial intelligence technology that are based in algorithms. So calculating the likelihood of the individual's behaviors, choices, health status, whatever that is personal, very much personal aspect of the people. It starts with data collection as well. Any available resources can be subject to preparing these algorithms. For the predictive policing aspect, the predictive tools have been used for identify or guess or predict what likelihood the person to repeat or to be guilty of a certain criminal act. For example, of course, these predictive tools have been used in many of the countries, first of all, in the US and in the UK, but then in some of the EU countries, like in the Netherlands and France, we can see some examples of the prediction tools that are used under law enforcement purposes. In the US, for example, Santa Cruz Police Department have been using predpol algorithm that was, of course, much discussed and criticized in the literature, but still they have been using it since 2011 to foresee possible places and possible crimes to be happening in a given time frame. Even though there is a few available literature about the success of these predictive tools anyway for the law enforcement purposes, because they are working with very low accuracy from my point of view at least, and statistical point of view as well, 55–60% of confidence level they are generating their outputs. For the biometric data processing, I'm sure everybody is familiar with, since we are under surveillance of many CCTVs in public spaces as well. But these are means of drones, body cams, CCTVs, both in public and private hold, and other type of biometric data processing facilities like real-time biometric processing activities. This is, of course, a prediction tool as well, because once it is being used to estimate whether this person is that person, so for identification purposes, it is again a prediction, as well as for the authentication. In the US, per week, approximately 30 million cams work and record 4 billion videos. So it's a huge amount of data. At least these resources are available. For the other countries, I don't have much information, for example, per week, how much video records they are making. In the US especially, these biometric data processing or CCTVs have been used for detecting protests or suppressing riots, identifying people involved in crimes, or reducing the physical contact during COVID time, so they didn't have to physically attend to the court hearings. So there are some good aspects, positive aspects of that technology as well. But of course, as all the other technologies, there are some risky aspects of biometric data processing, especially as the Big Brother Watch briefing has referred. With the help of these technologies, and especially those CCTVs, people became walking identities, because, of course, as the basis, they are processing just personal data, right? A little bit of technology behind, just to strengthen my point of view, why I'm referring again and again, these are personal data, even though the system was itself not firstly developed by personal data, it can be any data. During the system evaluation and output of the system evaluation, so the algorithmic assessment is a personal data, whether that person is Gizem or not, this is absolutely a personal data, right? So for the predictive policing, as we said, it's a classical artificial intelligence logic. So as very generally, I would say, so general, so nothing technical. There's the data collection, it can be any resources, cleaning the data if so, training the algorithm, testing, and feeding new requests. Of course, I put a dot there, but it's not the end of the system development, because with each new data, the system is being developed again and again. For the predictive policing, certain accuracy levels are set for risk assessing of unknown situation in generally. For the biometric data processing, there are two types of biometric data processing purposes, let's say. For the authentication, like we use in our mobile phones, for example, the system already knows who we are, so we already identified ourselves to the system, and once we put our fingerprint, for example, the system authenticates whether we are this person or not. There is not much problem here because we are under control of our own data. For one-to-many method, I would say that it is for identification or for prediction as well. For the unknown or already known situations for the person. So from one-to-many method, as they refer in the literature, at the end of the processing, the system actually ranks the accuracy levels from the lowest to highest level, whether the likelihood of that person to be possible criminal or not, for example, based on their biometric data. So at the end, we have a list of ranges or ranks in our after our evaluation. And what's wrong with that? Actually, why not? Of course, we should benefit from the technological tools, and we should be able to use them to ensure the national security or public security, and etc. Of course, these are very broad definitions. But for example, let's have a look at Amazon's recognition biometric data processing tool. That you can see that there are many features that are identified, very comprehensive field of uses you can see. And I just happen to know actually that the Amazon is planning to launch this emotional assessment tools for the personal, so private CCTVs as well. So our neighbor might be able to see whether we are sad or not when we are at their door. For the predictive policing tool, this is a real project, a real report actually that I just generated from the Metropolitan Police of the UK. So they are using this predictive policing tool for estimating whether such groups or persons belong to certain criminal groups. So you can see in their report that there are some scoring ranks like red, amber, green. They classify people. That you can see that the green means, of course, that less likelihood or no criminal bound with the person. I would say that 1,305 people's data was unnecessarily maybe fed to the system. You can see the ethnicity breakdown. I will, of course, switch from there to the discrimination question, and you can also see female and male numbers as well. So what are the problems? So I know that in the literature there is such a terminology saying that the algorithmic discrimination, but I do believe that, and I always try to stress in any of the opportunity, I try to use those opportunities to say that the discrimination belongs to human, and the systems are just simulating what human or what we do show them. Very, very logically, if we show a human even, not just a system, just one certain sample of the certain event, the human will start to evaluate the things just in that line, in that level. So for the system as well, if we only show that black people and men, they are likely to commit a crime all the time, and of course in the end the system output will give us more likelihood for a black and man person to commit a crime in the end. Discrimination is not just, of course, under the law enforcement authorities' hand, but for recruitment as well. Advertising, price discrimination is one of the biggest discrimination right now. Everybody faces as well. Image search, translation tools, and etc., etc. So it of course has some technical aspects. Statistical error is it is, as far as I know. So as long as the size of the sampling is representing only one or few features, the system starts to evaluate on that direction. This is what I wanted to say. So the machine sees some examples, some example data less or more than the others, and the evaluations are also in that direction. There is a court case in New York, State and Loomis case, where a person was judged, actually sentenced, based on the algorithmic assessments, and it was an exact example of the algorithmic discrimination. There can be other reasons why the technical problems occur, like wrong labeling, of course by human, choices of resources, of course by human, and dirty data, etc., etc. What I would like to highlight here is actually the accuracy level, because the Proposed AI Act as well speaks about some of the accuracy level. What is the acceptable accuracy level for identifying someone's likelihood to be a criminal or not? So I just said in the beginning, 55–60% of accuracy, whether it's acceptable or not for a person to be sentenced, even for to be judged, is it enough? And who decides these accuracy levels? For example, generally the developers, of course, identifies these accuracy levels, because they know how much data is qualified for. 95% of confidence level is not equal to 65%. Furthermore, and it's just more related to biometric data processing activities, here is the purpose limitation. With the biometric data processing, we are trying to identify, predict the unpredictable personalities, right? Whether the person is happy, whether she or he looks like a criminal, and etc. So once a CCTV camera is placed somewhere, we cannot really know what can be the extended purpose as well. I just, again, happen to know that law enforcement bodies of certain countries started to collaborate with the private companies, because their legal system certainly doesn't let them to collect data and assess people based on that data, but there is a legal loophole that they can use for the private companies as well. So I think it's logical for them, but set for the sake of data protection. Data minimization rule, of course, extensive data collection. Once there is a public CCTV, whomever passes from there will be a subject of recording of the cameras. For example, Cambridgeshire Constabulary's law enforcement data processing link is really worth to check for what purposes they are using, they are collecting, and for what extent they are collecting data. It's a very big list of purposes, so I couldn't just reflect here, but if you have time, you can maybe later check on. And right to remain anonymous, of course, we still do have a right to seek to remain anonymous in the public state. Even further, in the Perry and the United Kingdom case, the court decided that the people who enter in the police station still have a right to remain anonymous, even at the police station. So we, unfortunately, once the camera is placed there, we cannot really remain anonymous. Our data is being collected and being transferred and being processed at some level. And what about right to erasure? Of course, first of all, we should know, even in order to exercise our right to erasure, whether the law enforcement authorities do have our data or not. It's very untransparent for me. Or even if it is known, like in the Dimitrov and Kazakov case, These two poor guys try to tell the police and law enforcement authorities that they are not those persons that they are looking for, and they should just correct their data. So they should just put their data accurately, so there wouldn't be any other problem. But they were called to the police station several times. I'm coming to the end. I hope I didn't extend my time yet. But the related legislation, of course, the GDPR, the Law Enforcement Directive, and the proposed AI Act, very shortly, I would like to evaluate the proposed AI Act under the light of these problems that I just tried to highlight it. As you may already be familiar with the proposed AI Act, it brings us risk-based categorization for the algorithmic tools. So there is the unacceptable risk, such as subliminal manipulation or real-time biometric processing, with the very huge exceptions, like for search for victims of crime. And that is, of course, the reason we are using or operating these biometric processing tools anyway. And the high-risk category, that is including the prediction tools as well. So I think that the EU lawmaker was not brave enough just to ban the real-time biometric data processing tools under the proposed AI Act. It should be banned, as the European Parliament says. The news about from the European Parliament referred, and I'm actually expecting this to happen, both by public and private means. So for the public means, there are some exceptions, but for the private means, there is no regulation. There is no legal reference for that. So the private means can still keep using their real-time biometric processing tools. Why it should be banned anyway? Because it's contradictory to the purpose limitation, data minimization, and right to remain anonymous problems that I just referred. They can never solve it in that way. For the predictive policing tool, it's categorized under the high-risk tool, but it has huge use area, so there's a clear imbalance actually between the individual and the law enforcement authorities anyway, even though there are some good solutions like the necessity for the law enforcement authorities to show some technical means that they used for collecting data, how did they evaluate the data, whether they clean the data from biased indications, so the so-called data provenance. It's a good solution, but for the accuracy levels, for example, we still don't know who should decide the accuracy level. Also, the transparency and explanation. This is all about transparency and explanation anyway. From my point of view, law enforcement bodies are traditional institutional black boxes. So the systems are not just the ones who are which are black boxes, but these are the institutions. I don't know how much of us can really know whether the law enforcement body is assessing our personalities under an algorithmic assessment tools, and how much we can really go and ask for the law enforcement authorities to explain for what reason they were doing this, and at the end, if they reach a decision about us, how much we are able to contest that. So there are several ideas, of course, about how to solve it, but my idea would be to boost the public trainings and internal staff trainings for law enforcement bodies. That can be a good solution as well. These are the references I used, and thank you so much for listening to me.
Issue in the context of AI. Thank you very much. Something struck me in your presentation. Discrimination is not being made by the AI, it's us, because AI is being fed by our own data. Microsoft Tay robot, it's chatbot, and within 24 hours, from women, from races, it can become a monster. But the data is being given by the conversations, online conversations. Therefore, the data that we collect and the data we process, we need to be careful about their quality so that we can have reasonable results. And in addition to what you've already said, and in the AI, with the input and the output, the semantic relation needs to be understood and explainable. AI is a new concept under the AI, and the purpose of explainable AI is what Gizem mentioned to overcome those issues. Thank you very much. And let's find those names, later on. Now, last but not least, our final speaker, Dr. Nafiye Yüceda, and he's going to be talking about the legal results of showing the wrong legal reason in the clarification texts. Thank you very much. I would like to thank to the speakers for their nice presentations. Legal definition of this legal reason shown in the clarification text and its importance. I will be talking about that. When we talk about a legal reason, it's the clarification text that comes to our mind. When we look at the law, the legal cause is related to the obligation to clarify. In the Article 10 of Personal Data Protection Code, it says that the legal cause has to be shown, and again in the fulfillment of the procedures of the fulfillment of the clarification, right to clarify, there is an expression saying the legal cause. In the EU law, in GDPR, and in 95/46 directive, the purposes of the processing for which the personal data are intended, as well as the legal basis for the processing. Why the legal basis should be shown? What is the main purpose? Our main purpose is to see the compatibility of this person to this legal basis and see whether this processing is legal or not. While we are clarifying and fulfilling this obligation, our purpose is to say that the related person is knowledgeable, should get the information about the processing, and they can define the destiny of their personal data. But at the very beginning, clarification is very important, and the scope has to be defined very well, and the legal basis has to be one of the minimum elements of this text's clarification text. When we say legal basis, the obligation to clarify, but it might not be the case if the legal basis has not been shown or a wrong legal basis was shown in a clarification text. It's the violation of the right to clarify. It's going to be the breach to 10th article of Personal Data Protection Law, and the indemnity is going to be applied because of the violation of the right to clarify. This is the rule, but this is not an absolute approach. When there is a lack of fulfillment of the obligation to right to clarify, when there is a wrong legal basis, we are here not only mentioning about the violation of the right to clarify. This might be against the general provisions. In the 4th article of our code, general principles are explained, and these principles might be called as fundamental principles, and these are taken into consideration in fulfillment of the code. These are the skeleton of the code. In the clarification text, the legal basis has to be expressed, and this legal basis has to be in line with the honesty rule. Being in line with the honesty rule is a complementary part of being legal. What should we understand incompatible with the honesty rule? It's not that clear, but an idea says that this is the second article of the Turkish Civil Code. It's being visible here, but another opinion says that here this should be understood that the processing needs to be made fair, on a fair basis, and in the honesty rule and being fair are not the same things. And this perspective is resulting from 95/46 EU directive and the regulation GPDR. When we look at them in their English texts, processing needs to be made fairly. It's stated clearly. And from this perspective, being fair is not covering the rule of honesty. And this discussion has an importance of theory because, they come together in one certain point. The interest and the reasonable expectations of the related person needs to be taken into consideration. All these opinions come together at one certain point. We need to understand the rule of being honest, the rule of being fair, etc. It doesn't matter. The interests and the reasonable expectations of the related person have to be taken into consideration. The trust of the related person should not be misused. Being compatible with the honesty rule, let me take a deeper look. Protection obligation, being against the obligation of protection that we talk about in the Code of Obligation. It needs to be compatible with that honesty rule. What do I mean? When we say being against the obligation to protect, during the contract, after the contract, the parties need to protect their rights. But being against to that, in our law, there isn't any separate regulation about that. So we are omitting it from the rule of honesty. And in my opinion, when we say honesty rule with a more specific expression, here we are talking about the obligation to protect. There is a processing which is legal in appearance, but this processing is not considering the reasonable expectations of the related person, and it's exploiting the goodwill of the related person. Even if it is in line with the law, it's against the honesty rule. So what is important here? In the clarification text, if the reason, legal basis is not being shown, when is it going to be against honesty rule? European Data Protection Board and our Personal Data Protection Board, when we look at their opinion, this situation is about when there is an open consent, this might happen. In other words, there is a legal basis, this is open consent, but there is another reason, which is like the fulfillment of the contract. I mean, the owner of the data, it's in line with the law, the fulfillment of the contract, for example. But in the clarification text, how is it called? It is open consent. Yes, in appearance it is legal, but it is also misleading the related person. Why? Because the related person thinks that in the clarification text, it's open consent, the legal basis is open consent, I can take my consent back and this processing can end then. For this reason, the processing in appearance is in line with the law, and there is a legal basis to be in line with the law. It's against the law because the reasonable expectation of the related person is not fulfilled and the trust of the related person is being exploited. And in the decisions of the board, if there is another legal basis, but when there is an open consent, if it is, this is against the honesty rule. And similarly, in my opinion, for example, there is a decision about Amazon Turkey, and the board, when there is an open consent, it's against honesty rule. Similarly, European Union Data Protection Board, they say that in the open consent, when there is a reason of being compatible with the law, if they take consent, it is going to create unfair situation. So we do have the similar perspective with the board. However, maybe there needs to be a separation. To wrap up, we said that as a rule, the legal basis, right legal basis should be shown. If not, there is violation in the clarification text. But in some conditions, the related person's trust is being exploited and it is against the honesty rule, then processing becomes against law. This is what we said till now. So what is the difference going to be? It's not going to be the violation of the clarification text. The processing is going to be against law. Therefore, this is the violation of the 12th article of Personal Data Protection Code, and there's going to be financial indemnity because of the violation of the 12th article of the code. When can that happen? Especially when there is an open consent, when there is another legal basis. Because the related person was misled, and there should be a separation as stated in the doctrine is going to be proper, and my professor is defending it. Mesut Bey is sitting next to me, and according to this separation, when the consent has been taken back, the data responsible, if they continue processing the data, then it's conceiving or misleading the related person. It starts from that moment, and there is a violation of the general principles from that very moment. But till that moment, this legal basis was shown wrongfully. Is there going to be a sanction for that till that time? Even if the processing ended because of the taking the consent back, it's not going to be against the 12th article, but it's going to be against another legal article. Thank you very much. This is all. Thank you very much. This was our last presentation. Let's end our session. Thank you very much. I hope you benefited from these presentations. And I would also like to thank to our professors who made their presentations. Thank you very much, distinguished participants. Fourth session has ended. We would like to thank to all of our speakers and our moderator. Now we are going
izleyicilerimiz, 5. oturuma hoş geldiniz. Bu oturumda Sayın Doktor
We'll have Mr. Judge Dr. Fatih Özkul, Dr. Korhan Yerim, Dr. Sertaç Işıka, and lecturer, researcher Uğur Aşkın. And our moderator is Professor Dr. Adem Sözer. Thank you very much. Welcome to the first International Personal Data Protection Congress. It is co-hosted by Istanbul University, Personal Data Protection Board, and Turkish-German University. And we have come to the fifth session. Fatih Özkul will be talking about personal data protection in 1982 Constitution. Fatih, hello. I'd like to extend my salutations to you. You have 16 minutes. The floor is yours. We can't hear you.
Açtım hocam. Sürede aksama olursa herkese yansıyacağı için hemen başlıyorum. Şimdi benim konum Anayasa Mahkemesi kararları ışığında...
I'll start immediately and I'll be talking about the protection of personal data in the light of the Constitutional Court decisions of 1982. I'll be providing my criticisms for Constitutional Court because sometimes Constitutional Court prioritizes public interests, sometimes it prioritizes personal interests, and when it comes to the law in the personal protection data, even it is not in the Constitution, other articles of the Constitution could serve for the personal data. When people switched into collective living, people had certain responsibilities and tasks for the society that they live in, and there must be certain protective mechanisms because of that. And also, especially fundamental rights and freedoms and their protection have become an ideal that needs to be realized by reaching a further dimensions. As long as human being exists, this ideal will continue to exist even if it is partially interrupted. And in Turkey, constitutions are the parties which are going to ensure the fundamental rights and freedoms of the individuals. And when it is related to technology, we know that at this stage, protection of personal data is a constitutional right, and the concept of personal data includes all information related to specific or identifiable natural and legal persons with a broad interpretation. And that problem concerns the private sector as well as the public sector. It is also important that it is important to protect personal data as legal acceptance and securing of personal data. I'm just skipping the 1948 Convention, Universal Declaration of Human Rights, and also European Convention of Human Rights dated 1950s, our Constitution dated 1982 and 1924. I just will skip them. And we know that in the Constitution, in the second law, it talks about the individual's right to freely develop their material and spiritual existence. This is the Article 17, and also privacy of private life, Article 20, and inviolability of home, Article 21, confidentiality of communication, Article 22, religious and moral, the ability to be compelled to express conscientious convictions, Article 25, constitutes examples in this area. And also, individuals have the right to demand the protection of their fundamental rights and freedoms during the collection, storage, and processing of their personal data by state. And also, we can see that Constitutional Court, based on these provisions, had the authority to solve the disputes. So there were legal bases. So when we come to the decision of the Constitutional Court, as you all know, Court of Cassation does not apply at the legal remedies very frequently, but this is the case. So biometric identification system was used by the private hospital, and there is this law which is opened against the social security institution, and so maybe I can summarize the situation. Person here applies at a private health institution, but his biometric information is not registered in the social security institution. That's why they didn't accept these persons, and they also took it to the court case against a social security institution. And in the 61 article, it talks about everyone has a right to demand the protection of their personal data, and it says that apart from the urgent cases with biometric methods, correction of the identity must be made, or else there must be the ID card or driving license or a passport or some other official health documents must be shown. This is an obligation. However, when we look at regulation of SSI, this is a must. So biometric methodological correction of the ID has become an obligation. Otherwise, you can't get any service. So let's say that, okay, after the application decision, when it comes to the verification of the biometric methods and collection of personal data and processing of the personal data and the protection of the personal data procedures are not defined in the constitutional law and by the legislator without providing the basic frames, it is not possible to apply this rule, which is the concept of that objection lies at the Constitutional Court number 2 and 21. And here in this third paragraph of the relevant law, it talks about the general health insurance and the ones that persons have to take care of in order for them to enjoy their health rights. Apart from this urgent situations with biometric methods, IDs of these people must be verified. Okay, after putting this detection, it talks about the definition of the biometric data. With biometric data, verification of the biometric information must be made. So what is biometric data? It is something automatically approved, and it's something also physical and scalable. With these methods, persons could be identified whether they are these people, natural people, real people, and in the Constitutional Court it says that it is related to human rights and the ones that are in line with the rule of law. So it describes the rule of law in the Constitution in big chunks. So after that, there is also another principle of the rule of law. This is the certainty. So the principle of certainty does not describe legal certainty. It also talks about the judicial certainty. It is related to judicial regulations and accessibility and predictability. These kind of attributes must be met by the precedents of the court. So thanks to these remedies, legal and judicial certainty could be settled. Okay, it's a great broadening interpretation with respect to human rights, fundamental rights and freedoms, and to what extent they could be limited, based on what they could be limited. Okay, in the 20th article of Constitution, actually the third paragraph is very much important for us. Okay, again, in the 13th article, it says that 13th article in the Constitution, it talks about the human fundamental rights and freedoms without touching them. In the relevant constitutional codes, certain things could be limited, but those conditions should not be against the proportionality principle and the very essence of the Republic. So this annulment application before the Constitution Court could be accepted and they could annul this case decision. But we might feel that, but in the next stage, what happens? Let's see. Protection protection of the personal data, protection of the person's dignity, and the right for a person to improve their personality. Personal data can be protected. However, this right is not absolute and limitless due to 13th and 20th articles of the Constitution. Under certain circumstances, if it is not against proportionality principle, it could be limited with the law. Then it talks about some international rules. In this decision, which is the subject of the objection, when people apply at hospitals, they should provide their IDs with ID cards or a driving license or official company or public institution cards. And also, unless they have these documents with them, biometric method ID confirmation is needed. It describes any kind of information with respect to a person. It includes age and also name, surname, but it does not only involve these basic information. It includes passport number, ID number, hobbies, and so it broadens this concept. And it says that in this concept, rules that is subject to objective are without a doubt personal data. And again, it says that Constitutional Court, by the way, when I say public, I mean state. Constitutional Court gives decision in favor of state, in favor of public. ID verification with biometric methods could lead to some corruptions and damages, but this is another, but also method which is the concept of this objection here should also prevent exploitation in the health sector.
Sağlık hizmetlerinin elektronik ortamda güvenilir altyapılar üzerinde sağlanması ve hizmetten yararlanan kimliklerin saptanmasında geleneksel yöntemlerin eksiklikleri nedeniyle ortaya çıkan kötüye kullanımı önlenmesinin amaçlandığı belirtilmiştir.
So it says that, okay, on one side, it talks about fundamental rights and freedoms, and it also includes limitation of fundamental rights, but it also says that there is a state on the other side, so I'm in favor of a state. So towards the personal data protection, privacy protection, this is very much in line and proportional with the proposed target, and it is not against democratic public order, so it is not against Constitution. And the last part is very crucial. I am reading, that's why I just have 2 minutes. And also in this objection, data should, if it is stored and processed out of the scope, it is going to be given sanctions and punitive actions in the criminal law of Turkish code. But these are not the same things in Turkish criminal code. It is a norm, and the punishments are certain in this respect. But in the Constitutional Court, it is related to the annulment of a hearing proceeding with respect to the harms on the fundamental rights and freedoms. This is important, and I don't have time. So in the last part, I can tell you that in certain decrees of the court, counter votes are much more important for the justified decisions. So we need a justified reason here, and that reason here actually proves why the Constitutional Court decision is mistaken. I talked about the equality rights and also the private life, privacy, inviolability of home, and also confidentiality rights, spiritual existence. So, but I can tell you that a legal basis is very much sufficient, but when it comes to implementation, we can see some problems. The most important thing is the interpretation of the courts. The most important thing is how this interpretation is giving direction to further hearings. Thank you very much. I don't have time. Thank you so much. You have already underlined the basic problem of Turkey. Yes, our law, our legal basis is very crucial, but they are not implemented, they are not enacted, fulfilled, especially in the personal data protection area. We can see the similar things, and this is the problems on the implementation. We have to be thinking much and more on the implementation side. I guess with respect to questions and answers, there's nothing that we can do on the YouTube channel. There is no question, no, we can't, I guess, have questions. Okay, then we will continue. Thank you very much for your speech, for your presentation. If we have time at the end, maybe we can have an evaluation altogether. Now I would like to give the floor to the second speaker, Dr. Korhan Yerim, who will be talking about the text privacy and also crimes against personal data, the comparison between. The floor is yours.
The floor is yours.
Teşekkür ediyorum hocam. Kıymetli hocalarım, değerli katılımcılar.
Thank you very much, distinguished professors, distinguished participants. I would like to thank to the organizers.
Slaytımı paylaşacağım.
Basınca karşınıza çıkacak ve o zaman paylaşabileceksiniz. Evet, tamamdır.
Şu an gözüküyor mu hocam?
Gözüküyordu, tam ekran da yapmıştınız. Evet. Başlayabilirsiniz buradan.
Teşekkürler hocam. Öncelikle vergi mahremiyetinin ihlali suçuyla başlamak istiyorum.
I would like to start with the crime of tax privacy.
Vergi 362'de düzenleniyor.
It is being regulated in the 62, and those who have to comply with that, they need to be punished according to Turkish Penal Code. The sound is not well, that's why I have difficulty in hearing the speaker. And this regulation is missing, and legal regulation has to be made in this regard. (362) article of the tax procedure law, and in the 339 article of Turkish Penal Code, we can see that they match. And tax secrecy, tax privacy, the matter of the crime, and about that, the secrecy, we can say that these articles are about the privacy of the data. In collection of the tax, exposing the secrets of the public debtor is going to be a violation to the article. When we look at the German code, in German Penal Code, tax privacy should not be violated. If so, it's a crime. When we look at the legal value, protected legal value, taxpayer credentials The sound is very bad. I'm sorry about that. Again, exposing the taxpayer, and as a result of that, if that person suffers from any harm in his professional or private life, tax privacy should be provided, and public trust is another legal value. And when we look at the elements of the crime, the typicality, the first one, and the second one is the against law. The perpetrator, the defender, the action, result, and causality, and the matter of the crime. And after that, I will be talking about the second part. When we talk about the perpetrators of the crime, they need to be compatible with the tax privacy, and if these actions are committed by someone else, then it's going to be handled by Turkish Penal Code, not Turkish Tax Procedures Law. In 362, tax privacy, it has to be accepted by those who pay taxes, and these people, this crime is a special crime from the perspective of the perpetrator. When we look at tax procedures law, the clerks, tax authority clerks, and also those working in the related authorities and commissions and the board, these experts are the public officials dealing with the tax. When we look at the defendant, the victim of the crime, when we say that the tax the connection lost, I lost the connection. And from this perspective, legal person is not the perpetrator, they are the victims. And when we look at the causality, violation of the tax privacy, the action is regulated in the Tax Procedures Law 362, Article 362, and there are two types of that. The first one exposing the tax privacy, and the second one using tax credentials for his own interest or for third parties' interest, but using it is clearly stated. Exposing the tax privacy, the taxpayers' credentials, they do, if their credentials are being exposed to people who don't have the authority to receive that information, then it's considered as the violation, and this information should not be reached by people who are not related. Then it becomes violation to tax privacy, and tax privacy can only be applied to those taxpayers who are mentally stable and deaf person, for example. They can't learn what it says, and in the exposure happens by the people who are in charge. Then if it is commercial secret, then the Article 239 is going to be applied, Again,
vergi mahremiyeti dışında kalan ticari ya da ticari nitelikli olmayan bir hukuku öğreniyorsa ve ifşa ediyorsa yine bu durumda 136 ve 239. madde hükümleri gelecektir. İkinci hareketimiz vergi mahremiyetine konusunda
get the second part, using tax privacy for his own interest or for third parties' interest, with the threat to expose the secret, providing interest for himself or for the third party.
Bu anlamda bu suçun neticeli suç olduğu söyleniyor.
And this is, there is an interest before exposing the secret. This is a crime. This can be considered as a crime. And in terms of the result, the causality, when we look at that, the quality of the exposure of the secret is the action crime, and if it is about getting interest out of that, it's going to be another crime.
Aranmayacaktır. Eğer yarar sağlama durumu söz konusu ise burada
The speaker is reading a textbook. I'm trying to catch up with him. When we look at the material matter of the crime, the matter or credentials which are to be kept secret are the matter of the crime. And using tax privacy, there should be intention, special intention, and this part has not been regulated in the law in terms of being illegal, using the right and the consent of the related person. These are the reasons of being legal, and in terms of legitimate defense, if it is the words of taxpayer, then it's going to be accepted as the legitimate defense. Again, in terms of using the right, tax procedure law, 5th article, 4th paragraph, by the Ministry of Finance, when they announce it to the public, the journalists are not going to violate the tax privacy issue. And again, exposing the secret, if there is a consent of the victim, then it's going to be legal. If these actions can be seen, the intention is clear. If a taxpayer has to be in line with the code, if the credentials are being sent to the, let's say, journalist, and it doesn't reach that person, then it's going to be crime. And in terms of participation, it's possible to participate in this crime, helping or co-committing. And in terms of section, there is a reference to Turkish Penal Code, and only 239 provisions are going to be applied in terms of sanctions, and also 242. This is not going to be applied to legal person. Again, in the article of 239 of Turkish Penal Code, the complaint condition is not going to be looked for. Protection code on the protection of personal data. This entered into force in 2002. This is about real person, any kind of information belonging to real person, and taxpayers and the people about taxpayers, their accounts, their bank accounts, their wealth, their profession, all kinds of secrets that needs to be kept secret, all of them are considered as personal data within the scope of Code on the Protection of Personal Data. This is covering only real person, not legal person, and along with the tax procedures law, Article 8, along with real person, legal person become payer as well. When we compare them, the crimes committed against personal data, with the crime of tax privacy, if it is against the law, Personal Data Protection Code, the articles of 17 and 18, there are sanctions. In the 17th article, it is sanctions, and in the article of 18th, it's about another approach, and here there is a connection with the provisions of 135140 of Turkish Penal Code. The sound is very bad. There's interference. When we examine German Penal Code, German Federal Data Protection Code, there is a reference, German Federal Protection Law in the article of 29th. There is a reference in the German Penal Code articles. So they are interrelated, and these regulations are similar to Personal Data Protection Regulation. And when we look at Personal Data Protection Code, there are differences in the Turkish Penal Code as well, because when we look at the regulation, if there's Tax Procedure Code 362, Turkish Penal Code provisions are not going to be applied. Tax Procedures Law doesn't have anything about personal data protection. Personal Data Protection Code is going to be applied in such cases. The data is processed or can be transferred abroad. And again, in the 5th, 8th, 9th, and 27th article of Personal Data Protection Law, no open consent is required, and this is also criticized. That's all I wanted to say. Thank you very much. Thank you very much. This is a very comprehensive subject. You explained it very well. We need to say a couple of words. This is not a comparison. This is about a crime in the tax procedure law, its relation with the other law. I think the title needs to be changed. And the second one, there are a couple of technical matters. we don't say the matter of the subject. There are problems about the concepts and the wording. The wording has changed. Spatial intention, it's not in line with the law. About legitimate defense, let's say that there's an exposure of the privacy and there is a reaction from that. It's not going to be legitimate approach,
Dolayısıyla yani buradaki meşru savunma ancak başka bir şekilde olabilir. Yoksa mahremiyetle aşağılamaya karşı, o da hakaret etmesi bir meşru savunma sayılamaz. Dediğim gibi içtima hükümlerine dikkate alan bir başlık seçildi.
Yes, new title must be chosen, including some precedents. This is the problem in the tax procedural law. There are certain punishments with respect to tax secrecy, tax privacy, and there is also the public data protection law, but it includes misdemeanors, etc. So there is conflicts like private norms and general norms, special norms. Maybe the real reform is to implement the current laws, but if it's going to be a real reform, maybe we need to also include private law crime types in the Turkish criminal code, because there are certain amendments. If it is going to be published, you have to make a research about this. It's going to be very appropriate.
Üçüncü konuşmacı Dr. Sertaç.
Dr. Sertaç Işıkak will be talking about the crime of recording personal data. You have 16 minutes. I don't think so that I'll just exceed my time, and you will find the details in the text that is going to be published soon. Developments in the field of informatics enable to access and store informations, and proceedings of these accessed and stored information also provides the opportunity to intervene in the private lives of people through their informations. And we are the ones who made it easier to intervene in the lives of people through their informations in the social media especially. Later, this information, which was previously considered to be within the scope of privacy, has been preferred to be organized under the concept of personal data. First legislative regulations regarding the protection of personal data in Turkey were in the Turkish Penal Code by the law numbered 5237. And in the background of these regulations lies the Convention for the Protection of Individuals with regard to automatic processing of personal data. The acceptance of personal data as a constitutional right was ensured with the amendment made in 2010, but we became a party to this law in 2016. So the basis of this protection of personal data law is the Convention for the Protection of Individuals with regard to automatic processing of personal data. And actually criminal law should be the ultima ratio, the final destination that we have to apply maybe. In the crime of recording personal data, which is regulated in Article 135 of the Turkish Penal Code, the subject of crime is not defined precisely. Personal data is defined as an information relating to an identified or unidentifiable natural person. And the personal data protection law by the law number 6698, we have to think about ultima ratio all the time, and with the intervention of other disciplines of law can we really eliminate other breaches, violations. Of course, we know the importance of the personal data, and sensitive, vulnerable data are to be protected in the personal data protection law. There is some data with respect to private lives, but as I've stated before, and technological developments have immensely increased after this decision was enacted, and we have come across with more issues with respect to personal data after this law was enacted. When I checked this cassation court, court of appeals decisions, I've seen that this kind of courts are related to fights between friends. You have shared my phone number, you've shared my photograph, so many of the disputes were about these kind of issues. Of course, this is not something I'm underestimating. Of course, this is a right to be protected, but it must be the ultima ratio of the TPC, Turkish Penal Code. And again, the subject of crime is not defined precisely in the Article 135 of the Turkish Penal Code, but the ones who record the data illegally must be punished. This is against the certainty principle for the personal data, but the Constitution Court says that the data international, the basis are the international protection agreements and also the European Court of Human Rights, and based on these decisions, Constitutional Court said personal data concept should be evaluated, and we know that the concept without a doubt will be broadened. There is no limitation with respect to personal data, and when we have a look at the national and international jurisdiction precedents, this is not uncertain. For that reason, application to Constitutional Court was rejected, overruled. And if it talks about the number, telephone number and plate number and also personal data, they are also accepted as the personal data. For that reason, Constitutional Court rejected this application. Again, in 2016, we know that the personal data protection law was enacted, and the number 3 article, the definition of the personal data is given, and I'm not going to give you the details. Yes, there are certain details which is regulated on the Article 135. Systematic places that the crime is systematically committed. This is very crucial because it could be related to the general place or else as the crimes against the privacy of a person. So here with these different types, people could be protected, and specific to their personal data, their privacy, their private lives are protected. So as a legal value, we can say that. If we have a look at the material factors of the crime, first and foremost, let's talk about the topic or the subject. Actually, Article 135 and the rest of these articles, data protection and recording and non-erasal of the crimes, are defined as the crimes against personal data. There is no definition in the Turkish Penal Code, but personal data is the data with respect to persons' identity. It's a very broad framework, actually, and Court of Appeals actually gave some examples to define the concept of personal data in the Turkish Penal Code and also Turkish Penal Procedural Law. We can see much broader concepts of the personal data. Personal data might include ID information like name, surname, mother's name, father's name, and also place of birth and place of residential area, and also telephone number, e-post, email address, etc. Anything that can define the person can be accepted as the personal data by Constitution, by Court of Appeals. Again, in this respect, it must belong to a natural person. If it's a legal person, it can't be protected under Article 135. It's a commercial legal person. Then there could be the disclosure of the trade secrets. And in this concept, again, it must be definable. Anonymized information can't be personal data. And the information which is in the attributes of secrets By the way, personal data should not always have that secrecy or confidentiality. Even though it's not secret, personal data must be protected. But there's these two opinions. Certain things could be made public. So one opinion says that publicity or the information that is public is not subject to crime. So again, Court of Cassation says that because it has made public, it does not constitute a crime. But another opinion says that no, even if it is public, it's still personal data. But the evaluation of it must be made based on legality and publicity and also the consent of the persons. So these factors should be taken in consideration, and then the punishment or the crime evaluation must be made. It doesn't have to be secret necessarily. Any kind of information which is accessible to everyone could be also accepted personal data. In terms of subjects, certain details of the qualification of data is described based on the qualification of the data, for instance, ethnicity, political information, and sexual tendency, and also trade union connections of the person. If they are disclosed, then there could be aggravations on the punishments. The reason for the aggravation is related to the importance, significance of the data. So in this regard, there is this very important current information with respect to vaccination. Vaccination information is personal data without a doubt, but in the protection of the personal data, there are some exclusions. In the article number 28, under certain framework, this information could be processed. In the article 28, paragraph C with dot, it says that it could be arranged with certain conditions, circumstances, unless if they are threatening public security, public safety, national safety, security. If they are preventing this kind of attempts, then these information could be processed by public institutions. It is limited to public institutions, and processing could also be accepted as use. So the perpetrator could be everyone, but they can't be the legal persons. The victim of this crime must be natural person, not the legal person, and this crime subject is recording, of course. So in the personal data protection law, it's accepted as the processing of the information of the personal data, but it is the same with the use. And there is this definition in the article 1, paragraph 3, subparagraph B. If it is recorded with non-automatic ways and stored, readjusted, transferred, handed over, or transferred, it means that this is a crime. This is a broader definition than it is specified in Turkish Penal Code. When we say recording, there is this limitation here. Data is partially or fully non-automatically recorded. If it is the case, then we can also talk about the crime. But according to Turkish Penal Code, data, if it is recorded to CDs, telephones or notes or books, physical or non-physical, there is no difference. If it is recorded, it is recorded. The most important thing is that data is accessible later on and is something reachable by others. So we can't put a limitation for the means for recording. And it's, by the way, non-concrete, intangible threat, and this is the direct intention, including the consciousness of illicit, wrongful acts. In terms of legality, there are some general requirements in line with the Turkish Penal Code. So it talks about the consent of the individuals, because the consent of the individual can be very important for the punishments level. Again, in the 5th article of the Personal Data Protection Law, there are conditions of the processing of the personal data. It is explicitly mentioned in the law. There are certain issues. The conditions listed in the law, it must be made public. And also there is this assumed consent because of certain de facto impossibilities. People might not disclose their consent in order for their body dignity, wholeness, and other lives to be protected. Personal data must be protected and kept as secrets. This is something stipulated in the personal data. And in Turkish Penal Code, limited number of conditions are arranged, and I think it must be made equal to one another in the Turkish civil law and also in the Penal Code, and in the civil procedural, criminal procedural law, DNA evaluations in the 135th article, the fingerprints issues. In this law, we can have the chance to record personal data, but there are some conditions, and I don't want to give you them one by one. When we have a look at 137th article, there are certain common conditions. Public officials, if they misuse their authorities and record the personal data, then they are given certain punishments. And attempt or also jointly committing crime, these are also possible. And in terms of precedents, we can have some problems. So crimes against the secrecy of the private life, there are discussions about general norm and private lives, private norms. So norms with respect to privacy and private life are to be accepted as private norms, but the other group says it must be general public norms. But what does the Court of Appeal says? Actually, they don't say anything clear here, but they say that if a private life's image or private life's sound, which could be subject to 106, 136, 137, are doubtlessly personal data, they say that, and image or the sound of a person without their consent can't be recorded or taken photographs, or their voice or sound can't be recorded, and they are deemed as personal data in the 134, 35th, 36th materials, articles, and they say that it is private norm, and this is also personal data. 134th article arranges these kind of information, so the personal image and personal sound can't be used and disseminated. If it is the case, they say that again, it can't be used as data for the punishment of the crime. They also say that it is personal data, but it can't be used as well. So we can't see some clear boundaries for personal data definition. Yes. As I've stated, there is the private and special, private and public norm, secrecy, privacy, and they say that if it is under 136th article, then they say that the relevant law is implemented, not the other laws. Okay, thank you very much. Thank you so much. According to Turkish Turkish Penal Code reform, 2015 June 1, it was enacted. So there were certain areas which had not been arranged in Turkish law. For instance, having experiments on human body, it was first and foremost adjusted on Turkish Penal Code, but some other areas were then adjusted in some other procedural law. The information, personal data was very similar to that. For instance, stigmatization was very popular back then, but there was no amendment in the Turkish Penal Code, and during the harmonization to European Union, personal data protection law was to be enacted, but it was not made possible till 2016. And in Turkish Penal Code, there were certain crime adjustments and amendments, and there are technical sides of the personal data protection law. Certain adjustments and amendments were made based on the needs of the time. Recording, so if each and every recording must be deemed as crime, it's not certain, but based on that time, in order to protect the legal value effectively, certain items were written like that back then. So what should we do? Should we exclude certain things and protect the vulnerable and sensitive data as personal data? But as I've stated beforehand, the content of the personal data is very much broadened with the enactment of the personal data protection law. First and foremost, that protection was made possible in the Turkish Penal Code. If we had this personal data protection law in the very beginning, that would have been better, but at least there is these two different laws, but there could be some disputes, conflicts. After math, there will be more discussions. Now I'd like to invite last speaker.
Aşkın tarafından.
Our last speaker, Uğur Aşkın.
Teşekkür ederim Sayın Hocam. Saygılarımı sunuyorum. Hemen bir slaytımı pencereden ben de paylaşayım. Sanıyorum paylaştım hocam, değil mi? Evet, benim konum kişisel verileri koruma kurulu kararlarının yerine getirmesi.
My subject is misdemeanor of non-compliance with the decisions of the Personal Data Protection Board. The law on the protection of personal data, numbered 6698, the concept of personal data is defined in Article 3/1D, and according to this article, any information relating to an identified or unidentifiable natural person is personal data, and the legislator didn't clearly limit what personal data consists of, and preferred that the scope be determined by the practice. And based on the definition of personal data in the law numbered 6698, the elements of personal data can be determined. All kinds of information can be counted as the fact that the information belongs to a natural person. The identity of the natural person is determined or identifiable, and the information is associated with a natural person. If one of the specified points is missing, it's concluded that the information is not personal data. Misdemeanors are regulated in the misdemeanor law and other special law, and whether an act included in special laws is a misdemeanor is determined according to the sanction envisaged in return. And in this context, applying an administrative sanction for an injustice shows that it's a misdemeanor, and the legislator considers some violations of the right to protection of personal data as heavy, and it regulates it as a crime between 135, 138, and these crimes include recording personal data, illegally giving or seizing data, and destroying data. On the other hand, based on the principle that criminal law is a last resort, it considered it sufficient to regulate some forms of violations as misdemeanors. Thus, while some of the violations regarding the protection of personal data require punishment, some other violations require administrative sanctions. In the Article 18 of the Personal Data Protection Law, misdemeanors regarding personal data are regulated, and these: failure to fulfill the obligation of disclosure, failure to fulfill obligations regarding data security, and failure to fulfill the decisions made by the board, and violation of the obligation to register and notify in the data controllers registry. And the right to personal data protection is protected for the violation of the decisions of the Personal Data Protection Board, and anyone who has been violated can request that their personal data be protected by the data officer through the board. Here, the board conducts an examination on the complaint of the person concerned about the concrete incident or its own, and as a result, the board may request information and documents from the data controller, or may decide to conduct an on-site inspection. Ultimately, the data controller or the persons authorized by the board have to resolve the unlawful violations of personal data detected by the board, and otherwise it's the fault of not fulfilling the decisions of the board, and this has to be done within 30 days. The decisions taken by the board must be of an individual nature. Therefore, if the violation is determined to be widespread, the resolutions of the board do not constitute the subject of this misdemeanor, and failure to comply with the decisions of the board is a misdemeanor elective act. These are failure to send information and documents requested by the board related to the subject of the examination, and failure to provide on-site examination, failure to eliminate detected violations of the law, or failure to comply with decision to stop processing data or transferring data abroad. And since the failure to comply with the decisions of the board is an abstract misdemeanor of danger, no harm is required to occur after the performance of the specified acts. Therefore, by performing one of the acts specified in the law, this misdemeanor is formed. Here, the legislator alone considers the realization of these acts as a violation of the legal value. In the Personal Data Protection Article 15, this misdemeanor is defined, and in terms of execution, there is a privatization. Therefore, this misdemeanor is an action misdemeanor. Therefore, in the 15th article of misdemeanor law, the perpetrators of the misconduct for non-compliance with the decisions of the board are only real people, and these are the data controller or those authorized by this person who don't comply with the decisions made by the board. In fact, acts of non-compliance with the decisions of the board carried out only by the persons in question are a specific misdemeanor, and if the victim is here, they are real persons whose personal data have been violated or who have filed a claim for violation, and legal entities cannot be victims of this crime, since personal data consists only of information about natural persons. If these documents are not sent, then it's the neglect of the misdemeanor. And our second element is the perpetrator. In that regard, in the 18th article of Private Data Protection Code, those who fail to comply with the decisions of the board, and this obligation is, as we stated, legal, the data controllers, data responsible, or those authorized by the data responsible, and this has been defined in the code as well, and the data controller is in charge of the data. It might be legal or real person. Therefore, in terms of perpetrator, there is a characteristic which is SIGT 4. This is a specific misdemeanor. When we talk about legal entities, only real persons, as I stated earlier, can be the subject of the misdemeanor, may be the representative of a legal entity. Personal data protection code in the article of 18th. These misdemeanors are going to be, those administrative monetary sanctions can be applied for the legal person and the real person. The administrative monetary sanction is going to be the legal person. The victim of this misdemeanor, what have they done? These are the real person, and in the third article, the first paragraph of the Personal Data Protection Code, personal data belongs to real people, and legal entities cannot be victims of this crime. On the other hand, in terms of the subject, if there is a lack of fulfillment of the decisions of the board, sanctions are being applied, and also the public secret quality documents and information are not the matter of this misdemeanor, but public secret, what is it? This is not defined in the Personal Data Protection Code. This is defined in the Turkish Penal Code. The description is there under Turkish Penal Code, so this might be taken as a reference. Therefore, such information in the quality of public secret is not going to be under this misendeavor. The immaterial subject, this can be, failing to fulfill the decisions of the board. This misendeavor might be intention or without intention. Therefore, the data controller or those authorized by the data controller, the board might not be giving the information asked or not compensating for the problems or the not complying with the decision to transfer to abroad. It shows us that this misendeavor is an intentioned one. It might be unintentioned as well. Data controller or the people who have been authorized, they might not be careful enough, and then the data might leak, and the perpetrator might forget about to fulfill the decisions. So it might be intentioned or unintentioned. When we look at the 17th article of the Code of Misdemeanor, the administrative monetary sanction is going to be defined whether this was an intentioned or unintentioned crime. And in terms of being illegal, in Turkish Penal Code, it's veiled because in the 12th article of Turkish Misendeavor Code, the reasons of being against law are defined. Consent of the related person is very important, and the consent can be given about the personal data, because personal data is something the people have all the rights on, all the freedoms on. Therefore, such consents can be given about the personal data, but these people have to comply with the decisions of the board, because along with the decisions of Private Data Protection Board, they are trying to regulate the matter. Therefore, the consent of the people not to fulfill the decision of the board is not legal. And on the other hand, again, in the 12th article of the misdemeanor law, if there is no counter provision, then Turkish Penal Code is going to be applied. Therefore, there are conditions which are elevating the conditions of being misendeavored. Oh, I lost the sound. I lost the sound. Sorry. And there is an open provision. And again, in the Personal Data Protection Code, there is no provision about the exceptions. Second one is participation. Participation is possible, but in the Article 14th of the Code of Misdemeanor, there is a system of equality. So without looking at the participation level of the perpetrators, the same amount of administrative sanction, monetary sanction, is being applied. And when they make decision not to fulfill the decisions of the obligation, in such a situation, each data controller is applied monetary sanction, administrative sanction. And as in the 15th article, if the decisions of the board is not fulfilled for more than once, then additional monetary sanction is being applied. This misendeavor is a continuous one. After the monetary sanction is applied by the board, if the decisions are not still being fulfilled, it's possible to take another decision to apply sanction on the very same person. And this is a violation of an obligation. Therefore, the number of victims, we can't give administrative monetary sanction. Therefore, in terms of sanctions, in 18th article, administrative monetary sanction is being accepted, but the other administrative precautions were not accepted. This financial fine, can be given with the upper and lower level. 25,000 TL, 1 million TL is the upper limit of this sanction. I lost the sound again. If the data controller is the real person, directly administrative fine can be applied, but if that person is a legal one, 18th article of Personal Data Protection Code, this administrative money fines should be applied to real and... I lost the sound again. Thank you very much, Uğraşkın. Thank you very much for this presentation. Misendeavor Code is of great importance in Turkish Penal Code. We couldn't follow the slides, but it doesn't matter. So you really explained very well how to examine a misendeavor. I congratulate you on that, and I hope that administrative courts will remember that there is a code of misendeavor, and then they can watch how these codes are going to be applied in Turkey. There's a couple of technical points I will tell you when these notifications are published. Thank you very much. Faruk Bilir is with me, Yüksel Metin is with me, and thank you very much for organizing this event. Büşra Hanım is with us, and she's going to close the session. Distinguished guests, 5th session is over. Thank you very much. Next session is going to start at 12:30.